see, here's a text, and it says, I own a piece of property with my brother as joint tenants, rights of survivorship. What's going to happen when I pass away, she says.
Yes, it means the brother's going to own it.
Yeah. So joint tenants, rights of survivorship, when you have two or more owners of a piece of property, if any one of them passes away, their interest automatically passes to the survivors. And, good news, there's no probate required there. So what we don't know is a texter what her real goal is. And if the goal is, hey, Tom, if I pass away, I want my 1/2 interest to go to my family, she would need to change that deed and make them tenants in common.
Correct. And so I think, Tom, that is for anyone out there listening where they own property in particular with siblings.
Yeah.
Family property that they may be aware that they, number one, check to see exactly what your deed says. And certainly that's something where we can help. You give us a call and we're happy to tell you. If you give us the address of the property, we can tell you very quickly what that deed says and what that means. But then number two important is, what are your family goals? Individually and collectively, is it meant to be that it always stays in the family? Is each 1/2 going a different direction? Then that's how we can help from there. But you're right, the starting point is because we do have people that will call us that they own property throughout Florida where they own it with adult siblings.
Let's say that our caller is, well, we know our texter says that she and her brother own the property as joint tenants, rights of survivorship. Let's say she talked to her brother and the brother agrees, hey, no, that's not what we want. If I pass away, I want my half to go to my family. If you pass away, I want your 1/2 to go to your family.
Correct.
How do we fix it? Well, we could do a new deed. They would both sign off on it, and now we're simply conveying it back to the two of them, but we put the words after their names of tenants in common. But let's just say that she doesn't get along with her brother. And she says, brother's not going to sign something like that. Well, she unilaterally, with her signature alone, can cancel out that joint tenants of rights survivorship. So she would do a deed from her to her for her 1/2 interest. And then you put in the deed, the purpose of this deed is to change us from joint tenants rights of survivorship to tenants in common. So she could do it with her signature alone if she wanted to.
Right, exactly. In that, and hopefully, and again, certainly you're right, that happens and we can do that. And that, what I would consider would be like the worst case scenario, because we're not wanting to do it, we're really wanting to work with them. Because I think that there is a bigger picture that people would need to understand. That is that, one, it's about changing the deed. But then two, oftentimes it could mean that there's another document that we have to do with it, another legal document. Why? Because we're wanting to make sure that it avoids probate.
Right.
And that we are accomplishing the goals of each family and them as together.
You and I occasionally watch a TV show called Maine Cabin Masters. And
Yeah.
there was an episode one time where it started off by saying, well, way, way, way back in the day, let's say there were 7 gentlemen that they owned a fishing camp together, and they all agreed from the get-go. These 7 men agreed that whoever lives the longest ends up
Winner
with this
takes
thing.
all.
Yeah, exactly. So by the time Maine Cabin Masters came along, there was only one survivor. And I go, I know how they did this. All 7 names were on the deed.
Correct.
They made them all joint
tenants.
tenants, rights of survivorship.
Absolutely.
So
That's
each
the
one,
simple.
Yeah, as they passed away over the years, whoever lived the longest ended up owning the whole thing. And so the gentleman, he ended up, well, actually, it was their father who was the one that lived the longest between all these 6 or 7 gentlemen. And then the father passed away, and his kids inherited. But as soon as they said that was the plan was, and I knew how they accomplished it by the way they put the magic words on the deed: joint tenants, rights of survivorship.
Exactly. And if somebody says that to us, oh, we know there's 7 of us and winner takes all. That's the easiest scenario.
Yeah.
Okay. It's easy, one, for us to make sure that the deed is set up that way. And if not, it's very simple to change that. Where it does get a little bit more to it is when the 7 people each say, I want my share to go this way. I want my share to go this way.
Right.
That's when we get out of that simple.
The words in the law are quite clear: tenants in common or joint tenants, rights of survivorship. And you and me and anybody that's been to law school, there's always cases where people transpose those words.
Exactly.
Okay, it's not so they rather than put tenants in common, rather than put joint tenants rights survivorship, they'll put words like tenants, joint tenants in common.
Joint
rights,
tenants in common.
Yeah, exactly.
Right. And what does that mean? Tenants in common. At
Well,
the end of the day, if there's any confusion, it's going to revert to the tenants in common.
Well, eventually gets litigated by the courts, and the courts finally rule, okay, if they don't clearly state one way or another, take the words, and this is how we're going to interpret them as the courts.
Correct. Once again, and it also points to, just for listeners to realize, a 2-page deed. It's short, but you must make sure that every word is correct, legal, and the way that you intended to be as the owners.
Yeah, deeds look simple to prepare, but in my 40 years of law practice, I've had so many people call me or email me saying, Tom, can I do my own deed? Well, I know that when I go looking at a homemade deed, there's at least a 50% chance
that it's wrong,
that a mistake has been made on it. And so that mistake, if the person who prepared that deed and signed that deed, if they're still alive, fine, we can fix it. But if they're deceased, well, can't fix it now.
Right. And what people should understand is this. How does it impact? It impacts because whether it's you or whether it is your loved ones, relatives, or whoever is going to get it, it can create a marketable title situation. So now when somebody does go to sell it, again, that may not be today, it may not be tomorrow, but when they do, there's problems.
Yeah. And just to give an example for our listeners out there, in the state of Florida at least, every deed, a grantor, the person signing the deed, the person conveying the property, you must always put their marital status. The layman who's out there preparing a deed from John Doe, they don't know that. And if you don't put the marital status, we got problems.
Exactly.
Yeah. And why do we need to put marital status? Because here in the state of Florida, there are homestead laws that says that by the very fact of being married, your spouse automatically has an interest in the home you live in. I'm not talking about your rental property, your vacation home, your commercial property, your vacant lot. I'm talking
Homestead.
about the home you live in. And so that even if the home is in the husband's name only, he cannot convey it, he cannot mortgage it, he cannot refinance it without the signature of his wife, even though the deed's in his name only. So that's
Correct.
why when we see a deed, we have to know what the marital status was of the grantor to know whether or not that this was potentially his homestead property.
Exactly. And Tom, you're right that one of the most common mistakes on a homemade deed is they fail to put the marital status, period. Meaning you were using the great example of being married and putting married man, married woman, or married couple. However, period, you have to put a status.
Exactly. Got to put something down there. The other thing about deeds is that when people often call us and say, Tom, how much does it cost to prepare a deed? Well, I give them the good news. It's not all that expensive for the attorney's fees to do it. But a lot of deeds, you have to put documentary stamps on it.
Correct.
You have to pay the state of Florida for the privilege of transacting that business.
That's right.
And even if there's no money changing hands, those doc stamps are then going to be based on what the amount of the existing mortgage is.
1 minute.
Exactly.
So people are often surprised that, okay, the attorney's fees are not that much, but man, what I have to pay the state of Florida in doc stamps, man, that's the real deal breaker for a lot of people.
Right. When there's a mortgage on it, you have to consider that. And then you also have to say, though, too, the state of Florida, each state, each government, they have to make the money. There's no income tax in Florida. And this is one of the ways that Florida does make money when there are real estate changing hands,
Exactly right.
transactions.